Prospectus and their concepts. So under the Companies Act, when anyone have to initiate or incorporate a company, they are supposed to give the detailed information in a document called prospectus. So the today's video will consist of the different parts, including the concept of prospectus, the meaning of statement in lieu of prospectus, different types of prospectus, process of filing and issuing a prospectus, and conclusions. So as per details provided in the Companies Act, prospectus is defined any document which is described or issued as a prospectus. It may include any notice, circular, advertisement, or any other document acting as an invitation to offer from public. There are basically the essential points required to be called as a prospectus. Is the document should involve subscription to public shares or debentures, or it should invite a deposits. Such invitation should be made to the public on behalf of the company, and it should relate to the shares, debenture, or any other such instruments. So basically, when a company want to collect the money from the shareholders, they have to give a document informing the company details called as prospectus. There is also a concept called statement in lieu of prospectus. It is a document filed with the registrar of the companies when company has not issued the prospectus to the public for inviting the subscription for shares. It is just like a state prospectus, but it is called a statement in lieu of prospectus, because the details as per the format is required is not specifically mentioned in the statement in lieu of prospectus. Only basic details are provided. Every public company either issues a prospectus or file a statement in lieu of prospectus. So it is not mandatory to private company. Private company may file, but it is not mandatory. But when a private company converts into a public company, it must have to either file a prospectus if earlier issued, or it has to file a statement in lieu of prospectus. So this is the required. So many times students get confused between the concept of prospectus and lieu of prospectus. So this comparative chart will help you to understand. So prospectus basically means a legal document published by a company to invite general public for subscribing its shares and debentures, while statement in lieu of prospectus is a document issued by the company when it does not offer its securities for public subscription. Objective of prospectus is to encourage the public subscription, while statement in lieu of prospectus has an objective to be filed with the registrar of companies. Prospectus used when capital is raised from general public. Statement in lieu of prospectus is used when capital is raised from known sources, where the company is sure that the funds which they will be requiring has a sufficient amount, and they don't require the fund from general public. Content of prospectus, it is as prescribed by the Indian Companies Act. Content of statement in lieu of prospectus, similar to prospectus but in brief. For a prospectus, minimum subscription has to be stated, but in statement of lieu of prospectus, minimum subscription amount is not required to be mentioned. So let us see some part about the prospectus, advertisement, and the types of prospectus. Section 30 states the method or states the contents of the provisions regarding the advertisement of prospectus. This states that when in any manner the advertisement of a prospectus is published, it is mandatory to specify the content of the memorandum of a company regarding object, members' liability, amount of company's share capital, signatories, and number of shares subscribed by them, and the capital structure of the company. So this particular advertisement has a intent to provide the basic details of the company, Like the memorandum of association is a document which the external person should know. So through prospectus, the company can let the people know the various details about the company. So these are the four types of prospectus: red herring prospectus, shelf prospectus, abridged prospectus, and deemed prospectus. So under the red herring prospectus, it is a prospectus which lacks the complete particulars about the quantum of a price of a security. So as we know that sometimes the company may be new, so they may not be aware about how much price their securities is going to get. So for the price discovery mechanism, they can float the red herring prospectus to the people, and through which the people will come to know about their particular company's details, and they can subscribe to the company. So red herring prospectus is issued prior to the prospectus. So this type of prospectus need to be filled with the registrar at least 3 days prior to the opening of subscription list or the offer. Then, as you know that the offer, when it is floated, it has a cap price, it has a floor price. So red herring prospectus is just a mechanism through which you are pre-informing to the people about your company and its operations and its details. So when offer to securities closes, then the prospectus has to state total capital raised, either raised by the way of a debt or a share capital. It also has to state the closing price of securities. Any other details which have not been included in the prospectus need to be registered with the SEBI and registrar. Applicant or subscriber has a right under section 60(b)(7) to withdraw the application on any intimation of variation within 7 days of such intimation, and withdrawal should be communicated in the writing. So these are the details of the red herring prospectus. Next we are going to see the shelf prospectus. As we already know the meaning of a shelf is the different compartments which are made in a cupboard to keep the things properly. So this shelf prospectus can be defined as a prospectus which has been issued by any public financial institution, company or bank for one or more issues of securities or class of securities as mentioned in the prospectus. So when a shelf prospectus is issued, then the issuer does not need to issue a separate prospectus for each offer. He can offer or sell securities without issuing further prospectus. These provisions related to shelf prospectus has been discussed in section 3I. The regulations are provided in SEBI for the class or classes of companies that may file a shelf prospectus at the stage of the first offer of securities to the registrar. The prospectus shall prescribe the valid period of the prospectus, and it should not exceeding 1 year. This period commences from the opening date of the first offer of the securities. For any second or further offer, no separate prospectus is required. So while filling the shelf prospectus, a company is required to file an information memorandum along with the shelf prospectus. So when you are issuing a group of different types or class of securities or different types of share, so not required that you should file a separate prospectus for every security. This shelf prospectus will consist of all the information of the different securities. Now what is the information memorandum? Section 3I1 describes the information memorandum which has to be filed with the shelf prospectus. It should contain all the facts regarding the new charges created, what changes have undergone in the financial position of a company since the first offer of securities or between the two offers. It should be filed with the registrar within 3 months before the issue of second or subsequent offer made under the shelf prospectus. So when any company or a person has received an application for allotment of securities with advance payment of subscription before any changes have been made, then he must be informed about the changes. If he desires to withdraw the application within 15 days, then the money must be refunded to him. After the information memorandum has been filed, if any offer or securities is made, the memorandum along with the shelf prospectus is considered as an prospectus. So again, you can see the information memorandum is specifying more updated data. It is specifying the changes and the charges which has been created newly. So this has to be submitted along with the shelf prospectus. Next is abridged prospectus, is a summary of the prospectus filed before the registrar. It contains all the features of prospectus. An abridged prospectus contains all information of the prospectus in brief, so that it should be conveniently and quickly for the investor to know all the useful information in short. So section 33I of the Companies Act also state that when any form for the purchase of a security of a company is issued, it must be accompanied by the abridged prospectus. So it is very useful and materialistic information so that investor can take a rational decisions. It also reduces the cost to the public issue of the capital, and it is a short form of a prospectus. Fourth is about a deemed prospectus. So deemed prospectus, as the name states here, is being stated in section 25I. So when any company to offer securities for a sale to the public allots or agree to allot securities, the document will be considered as a deemed prospectus through which the offer is made to the public for sale. The document is deemed to be prospectus for the company for all purposes, and all the provisions of the content and liabilities of the prospectus will be applied upon. So you can see one case is there, SEBI versus Kununnam Kulam Paper Mills Limited. So in this case, it was held by the court that where a right issue is made to the existing members with the right to renounce in the favor of others, it become a deemed prospectus if the number of such other exceed 50. So again, try to understand the prospectus word means the information which has been given about the company in some form. So in this case, it is very clear that the right issues when the company has given a right to the existing shareholders to purchase or get allotment of the shares done in their name, and they are renouncing those rights for consideration of some other thing, and they are providing the information to other people, that is when it exceeds 50, then such information can be called as deemed prospectus. So providing the information of a company in some documentary way is a prospectus. So further, let us see the process of filing and issuing of prospectus. First of all, there has to be an application form under section 33. The application form for the securities is issued only when they are accompanied by a memorandum with all the features of prospectus, referred to as abridged prospectus. There are exceptions that when application form is issued as an invitation to a person to enter into underwriting agreement regarding securities, an application issued for the securities not offered to the public. So for these two cases, the application form is not required. Further, we will see the contents which have to be mentioned into the particular prospectus, that is the name and registered address of the office, its secretary, auditor, legal advisors, bankers, trustees, etc. Date of the opening and closing of the issue. Statement of the board of directors about separate bank account where receipts of issue are to be kept. Statement of the board of directors about the details of utilization and non-utilization of receipts of previous year. Consent of directors, auditors, bankers to the issue, experts' opinion. Authority for the issue and details for the resolution passed for it. Procedure and time schedule for the allotment and issue of securities. Capital structure in the manner which may be prescribed. What is the objective of the public offer? Objective of the business, its location. Particulars related with the risk factor of the specific project, gestation period of the project, any pending legal action or any important details related to the project. What is the minimum subscription which is required to be raised? Detail of directors, their remuneration, extent of interest in the company, and such other reports for the purpose of financial information of the auditor's report of profit and loss of 5 financial years, business and transaction